Hi, Tanya. Can I verify you can hear us online?
Yeah, I hear you fine. Thank you.
Great. Thank you so much.
Thanks, everyone. Thanks for your patience while we were in executive session. The time is now 8:07, and we can go ahead and start up with our primary BOT meeting. We took roll already, so we can just go into our first item is consent agenda. There's two warrants, some minutes. Any clarifying questions on those can go to Macy. Hearing none, I move to approve the consent agenda.
Second.
Macy.
Trustee Larson,
Yes.
Trustee Maris,
Yes.
Mayor Billy,
Yes.
Trustee Ty,
Yes.
Trustee Corvalon.
Yes.
Thank you so much.
Thank you. With that, we'll go into our informational item for the evening. And who is presenting for us? Macy.
I believe it's Tom Mahold this evening.
Oh, Tom. Welcome, Tom.
I know how to turn this on. I remember. For those of you who watched this afternoon, you probably saw Tim Walz step out into the spotlight and say, show generosity towards your neighbors and devote yourself to building the common good. And that's what I'm here to talk about. A bit of history. Chris Larson, I think you're online. Ordinance 808 is what set this Health and Human Services Fund up back in 2020, May 28th, 2020. It puts our Health and Human Services Fund is our town safety net. It's backed by our lodging tax. And so on April 7th, 2020, this thing was signed in. Chris Larson signed it. And it says, Ordinance 808 says that the HHS fund gets 51 to 99% of the revenues from the lodging and occupation tax. And it was 99% through 2023. The OTF, just to be clear, does not support the Nederland Food Pantry in any way. That's completely separate. We, as an organization for the 5 other organizations, do the work of administering this. But it is our safety net, and it's and the more I spend time with this, the more I learn that the safety net is getting stretched pretty thin. When I was on that side of the table, right in that chair, a couple of years back, when it was clear that the budget was going to run in the red, I opted to take the 99% contribution, dial it down to 51% to make to try and make the budget balance. When I look at this, though, it's an order of magnitude off, because whatever got taken from our safety net didn't come close to plugging the budget hole. So I'm not sure I would ever do something like that again. Let me lay it out for you. We've averaged at 99%, we average $4,500 a month of income. At 51%, we're averaging $1,866 versus $4,500. Our run rate right now is running well above what we're bringing in. So we're really chopping the safety net. We're having to say no to people. We haven't had to do that before. Our current balance, because that's what I'm here to talk about tonight, is roughly 27 grand. If at the current trajectory, that would be 8.4 months, but in reality, because things run behind, I talked with Rita Six about this, it's 4 months in arrears. We've got to go a lot longer than that. And I'm having to say no to people that really need the money already. So we're not going to solve this tonight. What I'm here to talk to you about is those of you that haven't been through this before, budgeting season's coming up in Q4. The amount of money to bring it back to the 99% is inconsequential, but we're going to need that to serve the people that we're serving. I've learned in the last 100 days how sad some of these stories can be. They're really sad. In some cases, it's people who are of means that underinsured and they had a baby get sick and they couldn't pay the bills. Others are elderly people who are going to end up being homeless. But in the end, I think we become really focused on what we need to look at. Number one is keeping roofs over people's heads, and the others is keeping families intact and bellies full, and making sure that cars aren't towed away and that people can get to work. I've been treasurer of the food pantry for a while, which makes me the fiduciary for this fund. And I can tell you, it was relatively well handled. When I took over management at the food pantry over Memorial Day, I really went back and audited all the books and took a really close look at how these funds were spent, and I didn't find anything I would disagree with at all. What I have started asking for is, number one, to make sure that the funds were put into their own account. They were sitting in the food pantry's account, which I wasn't comfortable with. I think it made the food pantry feel that they had more assets than they did, and it made the fund kind of disappear. Another thing I've done is there were on the things that need tightening down, whereas we had gas cards for people that needed gas. I made sure that people had cars to put gas into. And I suspect that if we lost anything, it was probably gas cards that were going for other purposes but we tightened that down. And I can tell you, looking back on the time that we've managed this fund, we're having the impact that we hope to have, which is the whole point. We've got somebody on board now at the food pantry whose job it is to work with people who find their backs against the wall, to look at other assets that they probably hadn't looked at, including helping them file for SNAP and other benefits they're entitled to. And we look at root causes of how they got in these situations to try and unwind them so their life isn't totally stressed out. As treasurer, I balance the account monthly and I watch it really closely. When applications come in from the 6 organizations, I check them out thoroughly to make sure that facts are really facts. That's one thing I learned from your side of the table, that facts aren't always facts. You really have to take a look at this. We've tightened up any loose ends. And in the end, if you look at orders of magnitude, the people served by the OTF fund are 1.5% of what Nederland Food Pantry serves each month. We've, in terms of numbers, it's the OTF is relatively small, but I want to make sure that the integrity is intact. But in the end, anybody that comes in is going to get fed, going to get clothed, going to get cared for socially, mentally, and physically, medically. And in the end, I just want to say that the fund is in good shape. I'll be coming back to you later this year because it's at 51%, we're going backwards. I'm having to say no to more people than I think that deserve to be said no to, given the amount of tax we're collecting from this particular source. And that in the end, somebody told me this morning, they said Nederland is not by any means a town of means, but it's a town of generosity and of compassion. And that's what I've tried to do with this fund. And I think we're making good progress and we're getting the impact that the town was hoping for. That's it.
You got, thanks, Tom. Any questions for Tom? So, we're going to start budget discussions actually potentially next in 2 weeks. We're going to start in August this year. We'll start sooner, but yeah, we'll definitely, if you come back, because this can't be overlooked, which you don't want us, we don't want us to overlook this. So yeah, just moving it back up to 99%.
Yeah, it's heartbreaking sometimes to say, no, we cap things at $5.99 per year, regardless of incidents. So when somebody comes in with a broken down car, in any number of things, $5.99 is what we can do. Because we're 5 organizations, sometimes we ask other organizations to dig in deep, but $5.99 is, if I went any higher, it would be insolvent really quick. So I'll be back.
Thanks.
Budget season's my favorite. I miss it.
Well, thanks. Thanks for that letter to the editor of gratitude. It was a good message. Take care. Awesome. Well, with that, we'll go into our first discussion item of the evening, which is on the marijuana license process. And that will be Macy and Jennifer.
So in our aim, we have some historical information on the adoption of the marijuana licensing throughout town. It's important to note that there is a cap on the number of marijuana licensed premises. However, there is not a process for determining how to distribute a license should a marijuana license become available under the cap. So we did have a marijuana license holder relinquish a license in February of 2024. So there is currently an available marijuana premise license. Without rules in place, this new license would be processed on a first come, first served basis. We are looking for direction on if 2 or more applicants should submit an application at the same time. And what we are requesting is a process such as this. If a license is available, any submitted application will be processed on a first come, first served basis. When all licenses are claimed, the clerk will accept contact information from persons desiring to obtain a license. These are called waiting applications. If a license is relinquished, the town clerk will contact those individuals who are waiting, who expressed an interest in the license. And if 2 or more applications were to be submitted on the same day, the town clerk will conduct a drawing of lot to determine the order for processing the applications. The first application in line for processing under the lot drawing will be processed according to NMC, and that applicant will need to meet all required regulations to receive a license. If that person obtains the license and the cap has been met, then the other applications will be denied. We are looking for guidance on how to handle these applications through process. Without a process, I could be in a difficult situation of determining who would receive that license first. So just looking to you, we are seeking direction on drafting an ordinance related to the procedure of processing marijuana license application when there is at least 1 available license.
Thanks, Macy. Any clarifying questions? Actually, anything you want to add first, Jennifer?
The only thing to add is that the intention really was to include this type of provision in the code when the cap was originally in place. However, because we were under the moratorium and the moratorium was about to expire for marijuana licenses, the thought was, let's just get the cap in place, get some other code changes in place, and then we can revisit how to distribute any available licenses should one become available, that process. So this would be probably a pretty simple code amendment for an ordinance. I don't see this as being a huge lift.
Any clarifying questions? Chris and Tanya?
Nope, no clarifyings.
No.
Okay. Thank you. With that, we'll go to public comment on our marijuana application process. And there's no one in the room, so our marijuana license process. If you are online and want to make a comment, please do. Raise your hand or start talking. Yeah, Kathleen, go ahead when you're ready. Kathleen, we can't hear you.
Hello?
Yep. We hear you. There's an echo. I don't know if
Yeah,
it's
I'm
yours.
getting away from my computer so I don't get feedback.
You sound good there.
Yeah, here we go. Kathleen Chipai, Magnolia Star Route, 22-year business owner. From what I remember, this was supposed to be happening from the beginning, which was we were going to take people's names and put them on a list. And Jen Mattson just referenced that, well, we passed this and then we changed some other things in the code. Those other things that were changed in the code were done in secret meetings that were not publicly announced. When Chris Larson was mayor, I filed a code complaint because none of those meetings were made public. And in those meetings, the town decided to basically take the use by right through zoning away from everybody that owns commercial space in Nederland at all, whether it's industrial or retail. Because now, instead of it being a use by right to have a retail pot shop in town, or a use by right to have an industrial cultivation in town, properly zoned in industrial, the town now is forcing every tenant of a cannabis business to go through the SRU process. So I have a problem with all of this, even though it's the fairest way was to take a list, even though we limited us to 4 stores. And I don't think we even need the limit anymore because at the beginning, there was people that wanted to have pot shops, and then, nobody's making money off pot anymore. The state's claiming they're losing money now. They're not making what they were. So, I just wanted to remind everyone that the meetings that took away everyone's use by right to have any kind of a pot shop in town were illegal. And Chris Larson ignored that in my co-complaint. And when he was mayor, and I wanted that to be on record now. I still dispute the 3 meetings that occurred in a 2-week period at odd times, like 10 in the morning, and we can still compare the list of the dates and times that Chris Larson gave me, and we can see that they are not on the calendar because they never occurred publicly. And so, I don't like moving forward with anything where there's been illegal activity in prior decision making that impacts this. So I do believe it is fair to take a list, and the next in line is the next in line. But at the same time, the creation of all the rules that have happened during this time period by Jem Madsen and Miranda Fisher was illegal. So I don't think there's any necessity to do anything at all, quite honestly. That's my public comment.
Thanks, Kathleen. Comments on the marijuana licensing process? Seeing no hands raised or hearing none, we'll go ahead and bring it back to the trustees, the BOT, for discussion and not a 4. Oh, let me think. So people would actually have to file on the day to have a lottery, is that what you said, or?
Yes, that's correct.
Okay, so it's just, if someone announces they're closing down shop, say we have 4 again, we get someone in there, and someone announces they're closing down shop, then,
We would open up and start accepting applications, and we would accept them as first come, first serve. And if in the rare circumstance that we receive 2 at the same time, then we have a definitive process in place of how to handle those 2 that came in at the same time.
that makes sense. Do we like announce when people are shutting down, or that just becomes known publicly?
We do not.
Okay. Is there value in that?
I'm not sure. I'm going to ask Attorney Madsen.
I think if this is a situation where, as Macy mentioned, that if all of the licenses are taken and you have your cap in place, if she's taking people's contact information, and then she would be contacting them once the license was relinquished. And that's where you could have a situation where you have multiple people submitting an application at the same time.
So you wouldn't be going through the list like one at a time. You'd just blast all the waiting list at the same time, see who responds.
Yeah,
or
I could BCC and email everybody at the
Yes.
same time for
Yeah.
sure. Mhm.
That's a
fair.
good suggestion, yeah. I'm gonna go to the aim here, if I can get my mouse to work. So the questions before the board, the staff seeks direction from the DOT on drafting an ordinance related to the procedure for processing marijuana license application when there is at least one available. You gave us really all your recommendations, and I would nod on proceeding towards an ordinance that's consistent with what you're thinking.
What is outlined here in terms of process?
Yeah, I would give a nod on proceeding with what you've outlined here. I don't myself, I don't have any change amendments. Does anyone else have any changes they recommend?
This is Chris. I'd agree. Moving forward with what's laid out in the aim, I think is a good way to bring this back to the board as an ordinance.
Okay, thanks, Chris. Tanya?
Yeah, sounds good.
Ty? Yep. And Tierney, I saw you nodding. Okay, cool. So you got a nod of a tip.
Is that all we need, Jennifer, to move forward? All right, great. Well, thank you guys so much.
Thank you. We appreciate it. So with that, we'll move on to town-owned parcels, title search that Britt has been working out for us. Go for it.
Yep. This is Britt. I just wanted to kind of let you guys know I'm going to be going really over the summary staff recommendations and recommendations that Attorney Madison had given me. I'm not going to go through each parcel, piece by piece. There's a lot of information here. I also linked the Google Drive. If you had any issues accessing, let me know. If you want to see kind of those documents that I mentioned. So the town of Nederland is actively exploring some public-private partnerships aimed at developing housing on town-owned land. The first steps really involve a comprehensive title review on these properties to determine whether existing title conditions may hinder development. During this review, it was determined that physical and electronic property files may not fully capture all the historical transactions and decisions related to certain parcels, specifically concerning restrictions, conservation easements, etc. Consequently, additionally, in-depth review is necessary to fully understand how these parcels might be utilized. Our recommendation as staff to further review these parcels to clarify which sites may be appropriate for development, if this is something the board's interested in. While we've gathered some really good information from these sites, additional details are really needed to determine the feasibility. We also would need legal review of the documents that transferred property interest to the town and other recorded documents. This further evaluation would be important because we need to learn whether or not there are any restrictions on the parcels for development. And we need to know if there will need to be an election for the sale of the parcels. To sell any of the parcels held for park purposes or other governmental purposes, the question of the sale and terms and conditions must be submitted to the voters at a regular or special election. So back to AIM. Another thing we noted as staff is with the legal review as well. It might take a contractor to perform some site assessments, which could include further survey work or feasibility studies. So undertaking this process is essential to ensure that we make informed decisions about the development of these potential parcels. So you will see, just to give this background, on May 7th, you all directed us to do title searches on all of these properties. All of them have been completed. There were, let's see, 0 Indian Peaks, 100 Sundown Trail, 62 Navajo Trail, 64 Navajo Trail, 73 Sundance Circle, 0 Big Spinks Drive, 0 West Spruce Street, 0 West Pine Street, 0 Peak to Peak Highway, 11 Navajo Trail, 51 Doe Trail, and 32 Wildwood Lane are the town-owned parcels that title searches were ran on. So I did want to note as well, they're all public zoned, which means multifamily dwelling units exceeding 4 dwelling units, mixed use, duplex, triplex, fourplex, and tiny house villages are allowed by special review use. You'll see that link there. On each parcel, I gave the size of the parcel. We also included information on water sewer infrastructure. Some of them would cost a little bit more to extend these or be able to provide that. Gave some site characteristics and any major kind of summaries on information I found on them. Again, would still want legal review on some of those documents we found. Other than that, let me go down here. Sorry, this is quite a big document. Really just wanted to ask the board if you had any questions after reviewing this, and wanted to know if you would like staff to do a more in-depth site assessment of these sites to determine which parcels are more feasible for us to keep continuing to have these conversations. I know it's a lot of information to digest. Happy to continue to provide information after this meeting as well from this document. And there's a lot of documents. But really just wanting to get you guys' feedback on, should we have Attorney Madison start looking into these legal reviews and really maybe figuring out which parcels make the most sense for me to continue to have these conversations when our housing coordinator comes on to continue to have these conversations. I'm also going to pass it to John to see if he has anything else to say, because it's kind of a lot of information to digest there.
I think Britt covered it pretty well. These site assessments, I think we might want to consider, once we have that legal review, identifying a few of these sites to start with, if that's something we want to do. It's likely going to require an RFP. I think those cost typically around $5,000 per site. And so we probably want to think about what that would include if we want to do any feasibility studies about what that development would look like. But I think we want to make sure we fully understand legal status of every site before we determine where we might put that housing.
So were these sites like initially picked just as all of our remaining pieces of public property, or did you all select these?
No, so these are all our parcels. Okay. There are definitely like 0 Big Springs and the Tilden Park are ones that developers have had interest in. Originally, we had found that there were some agreements with the original owners that a park, it would be used for a park or something along that lines. And so there's definitely parcels from looks wise, I'm not an engineer or anything, that developers are more interested in. So I think we could probably narrow down that from just a kind of perspective of looking at the land itself, some of them are pretty heavily forested and very steep and probably not doable. And then from there, I think it would make sense to have that legal review and really maybe further assess if it, makes sense. But that's just my opinion.
This is Tanya. I have a question about one of the properties
Yes.
that I can't figure out which one it is. It's the one, I think it's parcel 1583132011016. It's where in the title search, it says 18 acres for 18 residential units, but I'm not finding any property that has 18 acres. It says town's desire was to create affordable units and sell off some of those parcels. Proceeds must go in escrow. And it's in the title, it's
I believe that's the Mud Lake one, which split with
Yeah.
Wild Bear.
so it's
Um,
not 18 acres or it is 18 acres.
That's a good call. 1 second. I'm trying to find that exact one. I don't believe it is 18 anymore. Sorry, I'm just trying to.
Do you know how big it is now? Because it sounds like if that was a desire for those lots, maybe.
What was the parcel number again?
I think it's the one right above it. It says 158313201016. And I'm feeling like it's 1 point something acres, all that there is, so. But I'm not,
All right, give me one moment.
I mean, it looks like it's on Navajo Trail and it's combined with another lot and for a total of 1.08 acres, but the 18 acres for 18 houses threw me off.
Yes, sorry. I was just pulling, it is that 1.08 acres. I had just pulled information that I saw. It was an original IGA agreement that I saw within it. And so it's the south portion of the Mud Lake property. So it's no longer 18 acres. It was something that I had saw in there. I'm not sure, once it's legally reviewed, I don't know if there's still something to play in here or not. It's just something I saw worth
So
mentioning.
is it located adjacent to Wild Bear or Mud Lake area, or is it is it on Navajo Trail, or where exactly is that lot?
So this
It's
lot,
like south of Caribou, right?
yeah, Texas Lane is to the left and it's like right at that like peak point of Navajo Trail.
Oh, okay,
It's in
so
between you and Texas Lane.
oh,
or
I
Te-
see.
I'm saying
Is
that
it that
wrong.
one that has that little arm that comes up to Tejas? And okay, and so then it does it butt up to 128 then, or what does it butt up to?
It but up to, let's see here.
Or is it just to that forest behind the Caribou Room, maybe? I don't.
I'm
I'm just trying to, because I like.
no worries. I'm pulling it up.
I
Sorry.
think in the forest behind the Caribou Room.
Gotcha. And then don't we also own all that forest by the Caribou Room?
Right up to the,
Right, and
West
so I
side
have
of it.
another question about that neighborhood, because it's got all these covenants and stuff, like there was some of those lots where it said, oh, you can't have any outbuildings unless it's part of the house, you can only have this, this, and the other. How can their covenants trump our mountain residential building code standards? Like, if we just went through all of this to change code to make it easier to build accessory dwellings and multiple structures,
Mhm.
does their covenant have any teeth at all?
Yeah, I'm gonna let Attorney Madison answer that since I don't know from a legal standpoint.
Okay,
The
thanks.
covenants, the HOA covenants are essentially a contract between all of the property owners in that HOA. And so the covenants are binding against those property owners, and it's just another set of restrictions that the property owners have to comply with.
Right, I get that, but it's still zone mountain residential, I think, and we just loosened up all of our codes to allow multiple housing. So
Right.
what is, are those covenants even legal now?
Yes, they
To
are
say
legal
that.
because there's nothing that the town didn't do anything to say that an HOA cannot be more restrictive. So, if that's something that you want to do as a board is to consider putting in place a regulation that says that an HOA cannot be more restrictive related to accessory dwelling units or housing units, then, that's something you can do. But that's not part of the regulation that was adopted.
Gotcha.
But do we even need to, like our public land on inside an HOA that doesn't have to abide by their rules?
I'd have
anyways?
to look at what the documents say related to the town-owned property.
Yeah, it was in the notes on some of those properties that are up in that neighborhood. That's why I mentioned it.
Oh,
Yeah, some of them state like no businesses allowed on plot, one residential dwelling unit allowed, no more than 2 stories in a garage, and they have limitations on sizes.
But that then presumes town signed off as the property owner at that time to be part of that. You probably have to look.
that,
I'd
that
have to look
presumes
at
it, but that doesn't mean that that's what happened.
I'd have to look at it. Yeah. The town or the land was probably dedicated to the town for a particular reason. A lot of these, I shouldn't say a lot, some of these properties or parcels are dedicated to the town for park purposes, for open space. And that's what the plat says, is that that's the reason they're dedicated to the town, is for that purpose, not for development of a residential structure.
This is also the review that we need to do to make sure that we can identify the most feasible spots for development.
And then, so I have a clarifying question. This contractor we'd have to hire, Prop 123 doesn't pay for that kind of work, does it?
Possibly. It depends on how we do it. And it depends on the ownership of the land and a couple different things. But if we have some time to do this legal review and make sure we're identifying a couple of good spots, then we could also do some work on the backside and see if we could figure out a good funding source potentially.
Cool. And the RFP would go out. You mentioned RFP earlier for that work. Is that what you meant?
My gut feeling is that's probably what we want to do because I think
Yeah.
recently did this and it was like about $5,000 a site is what we were paying. So I think if there's multiple sites, we might want to consider that as the right action by our policies.
Don't we have to do RFPs for that kind of contract work anyway?
I think it would be appropriate, especially if we're doing multiple sites here.
Thanks. More clarifying questions for Tanya. Your hands raised? Is that from earlier, or do you have another question?
Yeah, but I do have another question. So basically, if any of these lots say they were donated and they're meant to be parks and only parks, we shouldn't even bother spending $5,000 to do the work on it, correct?
Right. Yes.
Okay, so are we gonna eliminate those and then do 5,000 each for every other one of these, or are there other ones we're thinking about eliminating?
The other thing we can do is a little bit more review with our water wastewater team to look at utilities, and because we did look at proximity of utilities, but their kind of professional opinion probably is the most valuable thing. So we could do a little bit of internal feasibility just to determine that kind of thing too, like how easy it would be for us to connect, and then bring back a list of priority sites for you.
Yeah, that would be great to narrow it down just a little bit more.
Yeah, I don't think all of these sites are feasible, just based
Yeah.
off site characteristics and information we already know from talking with previous developers when this all came about. So there are some that could be eliminated off the bat, I believe.
And where are we looking for funding for this, if we're gonna spend about 50,000?
There's a couple of different funding sources. Mary Billy mentioned Prop 123, which there might be a funding source there. We could also look at a tier 2 EIF grant, which from DOLA, which we haven't gotten in a while. And depending on how long this takes, that can be a pretty easy process with minimal match for a project like this for us. So there's a couple different potential options. The other thing is there's funding sources like Habitat for Humanity that might work with us on a project like that if we were interested in looking at a partnership like that. So we could bring back a list of alternative funding sources for you when we bring back a list of properties and have that conversation.
Great. Thank you so much.
Side note on habitat. So I went to some conference last year. I remember which one. That Habitat spoke. There was people from the state, and I ended up cornering them later and talking to them more. And they said that this has become kind of a, I think, Flagstaff, Habitat for Humanity Flagstaff chapter, I think it's called, or Flatirons chapter, which is out of like Broomfield. They had built a house up here maybe 15 years ago or something like that, and they had a hard time getting volunteers. They kind of backed out, and so we're not going to deal with Netherlands anymore. And so what he recommended, and Gilpin referred to as a Habitat for Humanity desert. They'd never done anything over there. So he recommended that we would potentially start our own, and because then the labor source would be up here already. And he talked about like going to churches, and that's often how chapters start. But so definitely Ropin and Gilpin and Western Boulder would be.
Yeah, I think maybe the Peak to Peak Human Services group,
Yeah.
that might be something they're interested in helping with.
Yeah, and this housing authority that we're studying with Gilpin too would be something to try to. That would just be another way to drum up, because there's they can join the Habitat for Humanity and International, and there's a lot more money there. So anyways, any more clarifying questions, Chris? Chris, Tierney or Ty?
Nope.
Okay. With that, we'll go to public comment. There is no one in the room, so Kathleen, your hand is up. I don't know if that's from before or for this. What? Okay, any other comments from folks regarding this next steps on the title search at our public lots for sake of building affordable housing primarily? Seeing no hands and hearing no voices, we'll bring it back to the board, and I'm going to go back to the right page here. So the question before the board is probably way at the end, huh?
Yeah, really, I think next steps would be we kind of narrow these parcels down, and then come back to you with that list. Would we want to ask for that legal review now or bring back that list first and make sure it's appropriate? John, I'm asking you.
I think we could do it either way. I think it might be nice to know that you have that are developable from a legal and a feasibility perspective. So I would kind of recommend that we do both if that's okay with the board. But I think we could do it the other way as well. If like,
Can you get specific? Do both?
both a feasibility study looking at utilities and just like kind of a eye test of buildability, and then or constructability, I guess, and then the legal review just to make sure there's no encumbrances or anything that we need to worry about.
I give a two-pronged approach.
Nod.
Not
3 nods. Tanya and Chris?
Nodding.
Yeah, sounds good.
5 nods.
Thank you.
Thanks, everybody. Appreciate it. With that, we will go to our next, to our number 3 discussion item, the National Electric Code, which is Jennifer and Britt.
I will be reading correctly if it is me, but this is a amendment to the building code regulations related to the adoption of the 2023 edition of National Electric Code. Just to give a summary, the Colorado General Assembly established the Colorado State Electrical Board and sets forth the duties and responsibilities of the State Electrical Board. The State Electrical Board is required to adopt state standards governing the construction, repairs, and additions in the installation of wiring apparatus and equipment for electrical light, heat, and power. The State Electrical Board is required to adopt the most current edition of the National Electric Code. Colorado law mandates that after the state electrical board adopts the most current edition of the National Electrical Code, local governments are required to adopt the same version of the Electrical Code or some stricter requirements. The National Electrical Code is considered to be the benchmark for safe electrical design, installation, and inspection to protect people and property from electrical hazards. In summer of 2023, the Colorado State Electrical Board adopted the 2023 edition of the National Electrical Code to be effective on August 1st, 2023. The town of Nederland is operating under the 2022 edition of the National Electrical Code. Colorado law requires the local governments enforce the 2023 Electrical Code 1 year after the state adopted the 2023 edition of the National Electrical Code. To be consistent with the enforcement of the 2023 version, the community planner and the town attorney recommend that the Board of Trustees amend the building code regulations to adopt the 2023 version. This ordinance would need to be adopted by reference of the National Electrical Code because the town would not include the entire electrical code in its ordinance. Under the state law, a code that is adopted by the reference needs the Board of Trustee agenda for 2 meetings, and there must be a notice of a public hearing 15 days and 8 days before the meeting on which the ordinance is adopted. Previous board actions in November 2021.
Can I actually real quick just ask a clarifying question? This might be Jennifer. So it says, under state law, code that is adopted by reference versus in entirety. On a BOT agenda for 2 meetings, and there must be notice, public hearing, 15 and 8 days prior. So why 2 hearings?
It's because it's adopted by reference. So at the first meeting that you're considering this.
So it's a discussion item.
Ordinance, it can be a discussion item. It can even be on your consent agenda, but essentially it's giving notice to the public that you're considering that you're adopting this other code by reference. And then there's a requirement in state law that you have to publish notice of your second public hearing or your second meeting 15 days in advance and 8 days in advance.
And then the second meeting, the second time it would come to us, the second meeting would be an action item or consent
Yes,
again?
action item, yes.
Okay.
Yes.
And is the reason we do it as a reference is because the NEC doesn't follow ICC?
I mean, all of your building
periods.
codes are adopted by reference because you don't have
They're NMC.
the code included within the Nederland Municipal Code. The other adoption by reference is the Model Traffic Code. That's the other code that towns typically adopt and that you've adopted is the Model Traffic Code. So it's your building codes and the Model Traffic Code.
That makes sense.
Yeah.
Okay. Go ahead.
Okay. Previous board actions in November 2021, the Board of Trustees approved ordinance number 823 and adopted the 2020 edition of the National Electrical Code. There are no financial considerations for adopting an ordinance. So staff is seeking direction from the Board of Trustees on drafting an ordinance related to the adoption of the 2023 edition. That is it.
Any clarifying questions, Britt or Jennifer? Tanya, and any clarifying questions?
Nope, it's not like we have much of a choice on it.
No.
We would do well to adopt it. Okay, with that, we'll go to public comment. Seeing none and hearing none, we'll bring it back for a nod of 4. I give a nod to
Nod.
Nod.
Tanya.
Yeah, nod.
Thank you.
Thank you.
Appreciate it. With that, we go to our 4th discussion item of the evening, the revisions to the BOT rules of procedure and electronic meeting practices. Jennifer?
Good evening, Mayor and Trustees. So this is a request. This is something that Miranda and I had been talking while is taking time to review the Board of Trustees rules of procedure and your electronic meeting practice. The rules of procedure is your governing document, and it includes a lot of different policies and procedures for how the Board of Trustees is supposed to handle their meeting practice, agenda setting, duties of members and the mayor, your order of business, rules of speaking. And it's really a good practice to visit these documents on a periodic basis, make sure that what your meeting practice is, that it's consistent with your rules of procedure, make sure that your rules of procedure are consistent with the law. In addition, recently there has been, well, let me back up and just say that the Board of Trustees rules of procedure state that the board is supposed to follow Robert's Rules of Order. Well, Robert's Rules of Order is a significant book. I believe it's over 800 pages, has very in-depth meeting practices, and really you need probably a parliamentarian to follow Robert's Rules of Order in detail. And so recently, a new publication has come out in Colorado titled Bob's Rules of Order. And Bob's Rules of Order is a short form version of Robert's Rules of Order. Has basically the same ideas, but it's simplified to meet the needs of local government. And so one of the changes to the Board of Trustees rules of procedures would be to consider adopting Bob's Rules of Orders for parliamentary procedure. I do have a copy of Bob's Rules of Order if you'd like to take a look at it. It's under 200 pages, but it's very condensed, easy to understand. And if the board adopted it, it would be something that the board could follow, and we would be confident that we were following those parliamentary procedures, as opposed where I have some questions as to whether we're actually following Robert's Rules of Orders. So that's one piece of this item. The other piece is that the board has adopted an electronic meeting policy included in your packet that was adopted in March 2022, shortly after the COVID declaration of local emergency was rescinded. And again, I think it's a good idea to revisit these documents to make sure that we're complying with those, take a look at where we identify changes that should be made, and see if we've learned from the 2 years from the adoption of those rules on other best practices that we can implement in that electronic meeting policy. So happy to answer any questions.
I'd love to see a new meeting platform because WebEx isn't cutting it. That's just the first clarifying statement.
Okay.
Clarifying questions?
What are some things that wanted to be changed? I feel like it's all pretty reasonable when I read the document that was provided, the rules of procedure.
Yeah, I mean, there's just things that could be tightened up. You know, there's requirements for notice of special meeting has to be written notice. Yes, I could probably be by email, but it just seems to be outdated.
Oh,
there's a requirement that you post the agenda 2 days in advance. Well, that doesn't comport with state law where you only have to provide notice 24 hours in advance. I think some of the language related to executive session is somewhat inconsistent with state law on executive session. There's discussion about public sign-up sheets. We don't do public sign-up sheets for public comment. So it's not a lot of changes, but some minor things so that, just to make sure that we're consistent with meeting practices. And then if there's other changes that you would like to look at, so that would be the time to discuss.
I
those
think
other
one was
changes.
like a 6:30 start time that we talked about last time, and that would be the start time, whether it's an executive. This was just an idea we threw out. I'm just not saying we're going to have to do this, but there seem to be people seem to like it. 6:30 start time. We first talked about 6, but it came to 6:30, and that would be whether it's executive session first or an open meeting, and then there would always be the same start time, which would be probably easier in some ways for the town staff, and or at least from a scheduling point of view, and the BOT, but it might be a little more confusing for the public, but when there's executive sessions. But part of that was to earlier, which that was one thing we talked about. And another thing I talked with you about was like, it's kind of been assumed, and the practice has been that the mayor is part of building the agenda with the town administrator, but I guess it's not actually in here. And so we would put that in there so that it's just kind of like basically the mayor or the trustees have a hand in the making of the agenda. And, 2 trustees can always say they want something in there, whether the mayor wants it or not, that needs to be in there too. And it just needs to be clear that the mayor or 2 trustees work with the town administrators set agendas, and it's, to prevent rogue town administrators.
I have a couple concerns that I saw after reading the document. I need some clarification on the term limits because it says no elected municipal official may serve more than 2 consecutive terms in office, except that with respect to terms of office which are 2 years or shorter. No official shall serve more than 3 consecutive terms in office. Terms are considered consecutive unless they are 4 years apart. Town voters may approve any modification or elimination of these term limits by vote. And to me, when I read this, no elected municipal official, to me means mayor or trustee. It's anybody elected. Because if we separate the two, then, Billy could piggyback from mayor to trustee to mayor after 2 years to trustee with no end in sight. And I'm not sure that's what was intended by this very short paragraph. And I'm wondering what the interpretation of this is. Are we saying that mayor and trustee can just flip-flop indefinitely? Because I'm not reading it that way. I'm reading it no elected official, regardless of position. What's everybody else's take on this, and how can we fix this? I think it's going to only be able to be fixed by vote.
Can you just say, do you know which page specifically that's?
Yeah, it's page 15 under miscellaneous. It's D.
15.
So it's
Okay.
page 15.
I also just want to chime in, was a court decision on this issue related to term limits and office of mayor and also council member. This was a City of Thornton decision, and the court held that there was no term limit violation. It was a similar situation, office of the mayor, council member was different.
Okay, but that's not how this is reading. It says no elected municipal official. It's not separating them into the different categories so that we can then indefinitely just be mayor, trustee, mayor, trustee, mayor, trustee until you don't want to do it anymore. That's what you're saying is allowed, but it's not what I'm reading. So if that's what you want to put in here, or we, which I don't think that's a good idea, then we need to change the wording on here. Because right now, no elected municipal official to me means regardless of position. This is in our own code. I don't know about the Colorado state statute.
Is it in code or is it? I'm
Well,
reading-
whatever this is, the rules of procedure that you were talking about, we have to amend, or maybe some things that are out of date. So is it, if it's not code, then we don't have to change anything. And we're just having this conversation because it's interesting. But if it's something that we have to change, like the posting or this, that, and the other, the sign up sheet, all the different things that Jennifer listed, that makes me think that we're bound to do it. But if we're not bound to do it,
Well, we're not doing a lot of those other things that we would theoretically then be bound to doing. Yeah, I guess we just need to go through this and alter the things like the sign up sheet. If we're going to do it, we need to do it. And then we're going to have to figure out a way to do that in a hybrid format.
sure.
It's
But for
challenging.
this particular one, it says it here, it has to be changed by a vote. If we want to change what we wrote here under D.
Well, I think it's a little bit more in-depth legal discussion than just because the town also has regulations, ordinances related to mayor's duty and trustees' duty that are outlined in the code. So this language here could be fleshed out more related to mayor's duties and trustees' duties.
Well, but then we need to change the language from no elected municipal official to no mayor or trustee can, to differentiate between, what official we're talking about. Because it's really not clear here. The way
Yeah,
this
this
is
Yeah,
written.
or maybe we say no elected municipal official may serve more than 2 consecutive terms in specific office, except that doesn't make sense because the mayor can do a 3rd term because they're shorter terms. So yeah, it does. No,
Yeah, no more than 3 is allowed for the mayor.
yeah, which is 6
But,
years. as
but
opposed
then
to
I
8
guess
years.
you're saying then that mayor can become a trustee without any time. That's what you want, I guess. That's what I'm interpreting it differently. And I
Right.
think that
I want,
this
but that's
is-
what
this
that's what
shouldn't
I
be-
interpret.
this shouldn't be up to our interpretation. I think this needs to be fleshed out a little more.
Well, and I think also to keep in mind that these are the rules and procedures, but these are not legal. These are not legally binding. We have a whole separate section within the town code that lays out the definition of mayor, trustee, term limits, and all of those then fall back on state statute. This is like a summary of our procedures, our rules that
Okay, so this
are,
doesn't,
but that are
have-
working definitions, are working things that maybe aren't correct, that need to be updated, but the actual code has these things well written because they are taken from the state statutes.
Yeah, we do. I mean, that's the recommendation. This document, make sure it's consistent with the Nederland Municipal Code, consistent with state law, and make those updates.
And to that, I agree. I think we definitely need to update our board procedures to take into account things like our hybrid policy, to take into account the fact we don't have signups, bring it back to how we are running our meetings today and currently versus this sort of document that's been modified over the last 15 years.
Jennifer, I have another question about absences. where it says, after 3 excused absences, any other absence shall be considered unexcused. Is that in reference also with executive sessions and work sessions, or is that specifically for Board of Trustee meetings?
The way that I read this, and I saw this earlier today, but the way that I read it is there are 3 absences in a row. Any absence thereafter shall be considered unexcused. So if a trustee misses 3 meetings in a row, then that 4th meeting is unexcused.
Did you see the in a row? I didn't see the in a row.
Doesn't, but
Well,
It
that's the
doesn't
thing.
say.
is We can't
in
just
the
have,
context, if you read it in the context with the other language of that paragraph, because essentially it says that absences are excused unless they're determined, somebody says that they should be unexcused. So it's just, it's not clear what is meant in that section, but that's my assumption is 3 consecutive meetings.
no, it says 3 regular meetings in a 2-year term. In the event a board member is absent for 3 regular meetings in a 2-year term, any absence thereafter shall be considered unexcused unless the Board of Trustees. And then I'm just reading this, and I'm just wondering, okay, then it says more than 3 unexcused absences. Okay, but then it says, I mean, it's pretty clear about it being within 2 years. And my question is,
Yeah,
this is
except
just
the
Board of
last,
Trustees, so executive sessions, work sessions don't count towards the 3? Is this something we want to keep? Is this something we want to, I mean, a lot of people have already missed 3 meetings, in just this, since April, so.
well, I think we have to, I mean, because it also, if you read the full context of that first paragraph, regular meetings of a 2-year term, any absence thereafter shall be considered unexcused unless the Board of Trustees has previously approved the extended absences. So extended absences is more of a sequence, serial absences. And I think the reality is, in a volunteer board where, we either some of us work from remote, travel for work or have other responsibilities as well as this, that, if we are going to get overly specific on this, then yeah, I think those numbers need to increase dramatically.
Yeah, I'm just bringing it up because it's in here. But apparently none of this is binding at all, so.
Right. Well, and it
kinda
has
like-
words like if you go to number 3, it says more than 3 unexcused absences with a 2-year term may subject a trustee to disciplinary action by a majority of vote. So, I can tell you from writing code, or writing standards, like may and shall have very different meanings, legally.
Right.
Well, and
I just don't know how important it is we revise anything, because a lot of it, needs to be revised.
yeah, this is your doc. This is the Board of Trustees.
But it's not binding, so.
Right. I mean, so you just think it's a waste of time?
Kind of, if things aren't binding, just like our comp plan, like we have to codify things because they're not binding. So if it's not in the code, if there's things that are important, then we should put in the code. And then if it's not, then it doesn't matter. It's just a document.
I mean, it's also a document that guides practice and is a public document that we all use to kind of organize ourselves. And I think that having it as close to reality does make sense to have it be.
Mm-hmm.
And it's a document that's also given to new trustees, to new mayors. And so it should be consistent with what the practices are and what's best meeting practices. So it's a training tool, essentially.
Could be worth considering what's really important to you in terms of your procedures here and what really matters and what maybe is fluffier, and looking at that too and maybe trying to streamline it a little bit so that we have a really good group understanding of how this is going to work. I think from my perspective too, being new, understanding these procedures is really important so that we're going through the right processes. And I think from a transparency perspective, this is something that we tell the public too, like this is how we're going to act and how we've agreed to act. And I think that's something that could be valuable, especially if we think about what does and doesn't need to be in there.
I agree. Yeah, I think I need the consistency piece because, I mean, mayors only have two-year terms. Trustees only have 4-year terms, and people come and go, there's staff turnover. So I think things that make things, streamlining it and making it less fluffy and making it shorter and simpler is a great idea. And then it's easier to follow because it's easier to understand what that is all in there. And, there's a procedure, and then it's this, the electronic meeting. I personally like the electronic meeting option and the hybrid. I mean, when I was on the planning commission, I remember the BZA, like I was traveling for work and I wanted to do a meeting. They're like, oh, we don't do hybrid meetings. I was like, well, what planet are you on at this point in 2010, or whenever it was, 2019, I was like, my work was completely, hybrid meetings happen, or, and remote meetings happen all the time. So I'm glad we've moved to this. And yeah, I think it, allows us to have 5 people here today versus 3, which means we could have had the meeting. So if there are things we need to look at to make current or more specific or, maybe simpler, then I think that's great. But I think both of the things could be simpler and clearer. Any other clarifying questions or clarifying statements before we go to, I'd like to go to public comment.
I just wanted to ask where in our code do we discuss the term limits it's actually codified? So I can find it.
Actually go to, you know how to find that search page in NFC?
It's not, I put in term limits and it doesn't come up.
Oh. Put in,
It's really, Trustee Corvalon, it's where it's talking about Chapter 2, Article 2, and talking about the mayor and the Board of Trustees.
Yeah, I read that where it's got the different duties, but and then the 4-year, 2-year terms, but there wasn't anything about term limits in that phrase.
And that's where that Thornton case relied on the discussion in the Thornton Municipal Code of the differences between the two offices.
So we don't have term limits at all then written in our code.
No.
So that the only term limit that we have that all written in our code is in this document that we're reviewing right now.
And the
It's not our
Constitution.
State statute overrules
and the
whatever we have
Constitution.
in our code.
It's
The state's Constitution.
Colorado Constitution.
Interesting.
Okay, with that, I'm going to go to public comment. There's no one in the room, so if folks online have public comment. Kathleen, go ahead.
Kathleen Chippai, 33-year resident, East Magnolia, 22-year business owner. The term limit is a constitutional amendment, and the point is that someone doesn't get to just sit on the board and sit on the board, no matter what their seat is. Now, the Thornton lawsuit and I was watching this because we had the same situation happen in Netherlands. And it was a woman that was sitting as a trustee and didn't finish her term. She was halfway through her term and she ran for mayor. The question I thought that was being answered by the court is, if you have not completed your term, does that mean you're termed out? And the same thing happened for Chris Larson in 2014. He was a trustee, I believe it was 2016. He first ran for mayor, but he had a 4-year seat on the BOT, and he decided to run for mayor 2 years in, and then he became mayor. So that's why I was following the Thornton case, because what happened in Thornton is the same thing that happened in Netherlands. Now, the judge ruled, since it wasn't a completed term, that it couldn't be considered a full term. But when you've served your full term, you're not supposed to be able to come back again. So I'm going to have to look back at that. But it was similar, Jen Madsen, but it wasn't what Tanya is identifying right now. I read the code. I read this Constitution to say exactly how Tanya says it, any official. And it doesn't matter which official it is. You're only allowed to have a maximum of 3 terms as a 2-year mayor, but then you have to take a 4-year break before you are on as an official, elected official on the board. So, yeah, I don't agree with Jen that it's similar and that we should just rely on that, because I'm not relying on that. Because how I remember it, it was over a person. If you served only half your term, was that considered a term? And no, the court ruled no, it was not, if I remember it correctly. I also, I want to point out, it's interesting to me that Jen and Miranda were trying to work on Robert's rules, and well, nobody's read it because it's long. This board has adopted how many alternative codes, including the International Building Code, which is 8,000 pages long? Nobody has read that, okay? It conflicts with Netherlands code all over the place, and I have pointed this out before when it comes to change of use and change of occupancy being used interchangeably in the International Building Code, but never being used interchangeably at all in Netherlands or in our code. Change of use in our code means
That's 3
you
minutes,
want to do
Kathleen.
something. You want to do something that's not allowed as a use by right through zoning. So I find it humorous that that time was spent on this when we should be spending time on
Time's up, so wrap it
people's
up.
loss of use of property rights is much more important.
Thank you. Any other public comments on this? Hearing none, we'll bring it back to the board for discussion and nods.
I would like to see some consistency with public comment with the 3-minute, because I know many times people speak for much longer than 3 minutes, and other times they get cut off. So I don't think it should be arbitrary. It's either 3 minutes or it's not. And like, the other day, we all were enjoying it. The guy from Very Nice Brewery was explaining to us
Yeah,
about how this was going to affect him. And he spoke for about 10 minutes, but we liked, it was very informative,
it was
but that's not
education.
okay. We can't, he's not part of he was public comment. If it was like added into the agenda, like now we're going to have this presentation by this resident, or if it was a letter that we read, but I just don't, and that's just one. Sometimes we like Kayla go on, and that's great. We like her. But that's just, to me, it's unfair. I see it
No,
all the time.
I'm with you. I think we do need a little bit more consistency with that, because it's true. It like varies. So yeah, I totally agree with you.
Thank you.
Sounds good. So the questions before the board, of staff seeks approval of direction from the BOT on revising the BOT rules of procedure and the electronic and hybrid meeting participation policy consistent with best practice and legal requirements. The next step would be to place the revised drafts on a future agenda for discussion with the Board of Trustees. I'd give a nod on what's do you need specifically more?
Well, hearing a little bit more from the Board of Trustees in the discussion, and I appreciate Town Administrator Kane's remark related to simplified procedures. We can start from scratch, and I've got a set of procedures that are much more simplified that we could start from rather than revision of what we have here. So if that's okay with everybody, that's what I would start with for the rules of procedure. And then just revise that electronic meeting policy.
That sounds good to me. Is there I know the 6:30 time was proposed. I didn't see it here. Maybe I overlooked it, but that would be good to
Okay.
put in there for us to discuss.
Yeah, it would definitely be a discussion item to come back to you.
Okay. So I nod to that.
I nod.
Nod.
Chris and Tanya? Tanya?
What are we nodding about? Having it come back as a discussion?
Well, yeah,
The
that
whole thing getting revised, and I'd just like to see
to a
that.
simplified, much more
Yeah,
straightforward.
I'd like to see like a document that, just explains what got cut out, like in a simple version, so we don't have to hold them back and forth, and it'd be nice to know what got cut out and why.
Yeah, I mean, I don't know whether, like, if it parallels the structure of the existing one, then it'd be nice to just have the strike through and red line, but if it's,
Yeah, the red line.
if it's completely structured differently, then I guess, basically you redline the whole old version and you underline the whole new version, and they don't necessarily fall in place, so. I
It'd
don't
be
know.
nice to have a summary of what got cut and why, just while we're reviewing it, just to make it easier for our discussion.
Or if you're starting from a new thing, just maybe have the new one, old one, new one, old one, just so we can compare.
We could prepare a name that would show you, that would give you a background information about what was there and what's not there and why. That would be not too, I think we can make that happen.
Okay.
Thank you.
So basically following the structure of the old one, but
Yeah, if it's
Enough
a new
to
document, we'll
track of
make sure that you
subject.
have information about what existed and what doesn't. Especially if it's much shorter, we may have to tell that story a little bit, but we'll make sure that we give you all the information.
okay,
Sweet.
that works for me. Tanya, does that sound good? We already got 4 now. Just wondering if that works for you.
Yeah,
Great. Thank you. Appreciate it.
I have another suggestion that I would like to see added into the regulations, and it's something that we have in practice, and I'm trying to pull up the minutes from when this resolution was adopted, and I don't have internet. But it's my recollection that we agreed on a process to reach out and take, as staff, reach out to the board and take quorum and ask people how they are attending the meeting. And we require 4 members to attend in person in order to set up this room. It's a large impact on the community center staff. They have senior lunch the very next day. They have to take up and tear it down.
I think we're doing that. Nikki pulled out this afternoon because of a work conflict. We had 4 people here. Isn't it? I thought we were doing that. If 4 people can't be in person, we do go fully remote.
So yes, that's what we would do. And I would like that to be outlined in these procedures.
Oh, okay, because it's not written down.
Yes.
Was it not known that she pulled out?
I had no idea.
Okay.
Oh, it happened at like 5 o'clock. And yeah, we can't like break down the room because someone cancels last minute. And that's going to happen. People are going to
Okay. I'm
get
just-
stuck in snow.
Can we please add our procedure into writing? The
Oh,
one
that you want 4 people
Yes.
in person too. But isn't it already? You just said that
It's
procedure.
in this document, and I'm asking
Where is it?
that we add it, please.
Oh, yeah. Sure. I mean,
Yeah, if it's not in there,
it's that makes sense. All right. With that, we'll go to public comment agenda items. 3 minutes. There's no one in the room. If anyone has a public comment on a non-agenda item, you have 3 minutes. Kathleen, I see your hand is up. I don't know if that's from the last time.
Can you hear me?
Yes, I can.
Great. Kathleen Chipai. I'm going to continue on about term limit because I want to remind everybody that in 2021, in the packets, I found that both Miranda and Jen Madsen were saying that Chris Larson could run for a 4th term as the mayor, and that was not true. And I had to be very public about that. And then the town didn't even say, oops, our mistake. No, Chris just didn't run. But I really want this court case looked into, and I'm going to have to, I'm not in front of my computer right now, but I will be looking up what the state constitution actually says, because there is a point in term limits, and there, you don't get to just get rid of them. And there's been many citations in the Nederland Code and these documents like policies and procedures that aren't transferred correctly, shall I say. So the language doesn't match within the state constitution oftentimes. But there is term limits, and they are mandated in the state of Colorado. And the more I think about that Thornton case, the more I'm thinking that the dispute was, if you've done half a term, is that considered a term that would disqualify you from taking on a different seat that would give you 2 or 4 more years? And if I remember correctly, the ruling was no, if you had not finished your term out. And that would read as Tanya was reading it, and as I also am reading it, which is any official seat. And I definitely want this looked into further because like I said, in the Ames in 2021 December packets and January 2022, Jen and Miranda were saying that Chris Larson could run a 4th term as mayor, and that was completely inaccurate and unconstitutional. So I'm not even sure this comment that says if you want to change the term limit, there has to be term limits. Maybe you can change the term limits in the number of years, but you can't just stay there back and forth like what Tanya just accurately described could happen. The whole point of the state voters saying no, demanding term limits, was to prevent the same people from sitting in over and over and over, and then ending up kind of controlling and pushing in the direction they want to go when there's other people, especially when there's other people that are willing to run, which we've had
Thanks,
in numerous.
Kathleen. That's your time. Appreciate it.
Yeah, of course it is.
Well, it's 3 actual minutes. What about time to? Thank you. Any other public comment on non-agenda items? Any other business? Jonathan.
Mayor and board, today I had a conversation with Teens Inc. And before the referendum, they had applied for a grant for the childcare facility before they knew that there would be a delay in the process. And they found out today or yesterday that they're in the running as a finalist for that funding, which is a fairly significant amount of money that would help them further this project. And what they need from us, they had originally said that they would have that lease done. There's still some process required to, now that the referendum is passed, it needs to happen. The lots from that right-of-way vacation need to be consolidated into the other lot, and that takes a little bit of time. The reason we need that is because we need a good legal description on the lease, and we need to make sure all the land use processes are completely finished so that we can do that. So what they've asked is if we would be willing to write a letter, which would be similar to a letter of support that we'd give to another agency for a grant, that just says that our intention is to enter a lease with Teens Inc., the referendum passed, and that we've got these processes to work through, and then that the lease would be forthcoming in the near future. I think that we're in a pretty good spot to bring a lease back to the board in the very near future. We had been aiming for the 20th. I don't know if that is a feasible date, just to try to get a final draft of that to you. And we also need to get the legal description done first. So you wouldn't be able to prove anything on the 20th, but I do think it'd be feasible to get that done in the near future. And so what I'm asking for is permission to issue them a letter that says kind of what I've just told you, that we have a little bit of land use process to do, but that the intention would be to enter a lease with Teens Inc. to allow for the construction of the childcare facility.
So say that last statement.
So
You would need,
yeah, they would like us to just give them a letter that they could give the granting agency that says that it doesn't need to be binding legally, but just that the intention right now would be to enter a lease with them that would allow them to construct this facility.
okay. So that's something you could draft or?
Yeah, they had sent me one and I need to edit it, but it would basically say, I need to make sure it's aligned. I'd probably show Attorney Madsen just so she could look over it and make sure we're in comfortable legal space. But the urgency is that they need the letter tomorrow to move forward in the grant process.
Okay.
And so it's a little bit abrupt, but I think we could probably get something to them if it's okay with you guys.
Okay.
Yeah.
Good.
Sounds good. Any other business? I move to adjourn.
Mayor Billy,
Yes.
Trustee Corvalon,
Yes.
Trustee Ty,
Yes.
Trustee Maris,
Yes.
and Trustee Larson.
Yes.
Okay, thank you. This meeting is adjourned at 9:39 p.m.
Good night.
Thanks, everyone.